Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about trial argument. Cases that should have gone to the Supreme Court of Canada, but didn't. Stephen Fraser was convicted in a murder trial, and part of the pathway to his conviction included Crown Counsel's closing submissions at trial. During both cross-examination and then in their closing argument, Crown Counsel suggested to Mr. Fraser that his story, which had changed between the version of events he told police and the version of events he testified to at trial, was tailored to respond to information that he only received upon getting the disclosure in his criminal case. Mr. Fraser argued that his conviction was unfair as a result of Crown Counsel's improper suggestion to the jury that a person would tailor their evidence to respond to disclosure. And this case raises very important issues. Not only is the decision of the British Columbia Court of Appeal case here in conflict with an earlier decision from the Ontario Court of Appeal on this very issue, but it also raises concerns about the fairness of trial process if it is permissible, in fact, for Crown Counsel to suggest that a person would be motivated to fabricate their evidence upon receiving disclosure in a case. It doesn't seem right, on the face of it, that a person could suggest that the constitutional entitlement that an accused person has at a criminal trial to disclosure should then lead to a conclusion that they lack credibility because they present new evidence in response to that disclosure. And while giving an interview to police are entitled to engage in some levels of trickery and in withholding information from individuals in order to secure confessions. But if a person isn't given the opportunity to respond to or confronted with certain evidentiary details that might change their answer or that might necessitate some sort of explanation for them that leads to seemingly inconsistent evidence, then is it really fair to point to that evidence as being something that suggests that they are lying? To me, this case is very concerning, because it suggests a slippery slope might be taken in our criminal trials in the future, whereby people's exercise of their constitutional rights to know and respond to the case against them, and to understand what evidence is going to be led in trial in order to be prepared, and the great protection that we're supposed to have for the presumption of innocence, is slowly being eroded. And the Supreme Court of Canada had the opportunity not only to clarify how this doesn't erode those important constitutional principles, but also to clarify how this reconciles with other jurisprudence from other appellate courts in Canada. And unfortunately, the Supreme Court of Canada didn't take this opportunity. I hope that Crown Counsel across Canada doesn't take the Supreme Court of Canada's decision on leave as an invitation to start to make these submissions more often. And I hope that these cases will only be the rarest of cases in the most unique of circumstances. But that remains to be seen. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.